Get ready for the legal passage relating to shorthand, that is 80 words per minute. Start. In this regard, insofar as the allopathic doctors are concerned, the Indian Medical Council Act 1956 provides for the constitution or reconstitution of the Medical Council of India and the maintenance of the medical register, so long as the name of the medical practitioner is reflected in the register maintained by the Medical Council of India in terms of MCI regulations 2000. The said medical practitioner can be called a registered medical practitioner. As for the alternative medicines, the Parliament has also brought out an enactment, namely Homeopathy Central Council Act 1973, an enactment analogous to the Indian Medical Council of Act to regulate the activities of the practitioners of that branch of medicine. In fact, under the said enactment as well, there is a particular provision which is in pari materia with section 27 of the Indian Council Act. A perusal of the above provisions would amply indicate that the privileges that have been extended in both categories are identical in nature. As such, in the absence of any statutory limitation imposed in accepting the medical certificates issued by the registered medical practitioners of homeopathy, it can't be said that the respondent bank has acted well within its power in terms of the regulations governing its employees to reject the sick leave applications on a simple premise that the medical certificates were not issued by an allopathic doctor. Before parting with the issue, it may be apposite to refer to a decision of this court rendered by a learned single judge in state of Andhra Pradesh through its Secretary Transport, Roads and Building and others. In the said case, the government issued GOMS number 25 Transport, Roads and Building dated 16/2/1992, declaring that the registered medical practitioners possessing the degree, that is MBBS, in allopathy or any equivalent qualification of any university in India alone are empowered to issue medical certificates for the purpose of obtaining the learner's license and conductor's license. The petitioner therein, who is an RMP in homeopathy, questioned the validity of the above GO before this court. In that context, the learned single judge of this court has held that Homeo and Unani registered medical practitioners have no special qualification or any study in such course to issue physical fitness certificates, that is, with regard to the applicants suffering from other ailments. Having held thus, This court has upheld the government order insofar as the facts of the present case are concerned. In the first place, the respondent bank has not produced any regulation or administrative instruction invalidating the medical certificates issued by the registered medical practitioners of the alternative branches of medicine. On the other hand, declaring general fitness on examination of a supposedly healthy person is different from treating a patient of general maladies and ailments. No particular branch of medicine can arrogate to itself the sole privilege of exclusive expertise. Thus, a person cannot be curtailed from taking recourse to alternative medicine. In such an event, if a person avails himself of treatment of any branch of alternative medicine such as Ayurveda, homeopathy, he can only be expected to produce certificate issued by the treating doctor alone. As such, in my considered opinion, the stand of the respondent bank cannot be sustained to the effect that only of medical certificate issued by a registered medical practitioner in allopathy should be taken into account, but not other certificates. Thank you. Get ready for the legal passage relating to shorthand, that is 80 words per minute.